Good day, Crime Talk aficionados. We have newly released video from the Moscow Police Department of Bryan Kohberger stalking around the night of November of 2022. Prosecutors are going to go after the death penalty in the family massacre where the infant was abandoned. The accused killer of the Pepperdine Quartet hires Karen Reed's attorney. Is it going to make a difference? Will Donna Adelson take a plea deal right before trial? We've got a story of a fraudulent nurse who dupes hospitals and treats thousands of patients. We have This Day in Legal History, our legal quote of the day, and our dumb McCriminal. Wait until you hear this story. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. Now, you know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell. And yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to the docket, let me remind you to go to crimetalksearch.com. All right? And you may say, my goodness, Scott, why do I need to do a background search on anyone? Well, because you never know. All right. Whether you're getting into a relationship or maybe things just aren't right in the relationship, go check it out. Go see what you find out. Go check out and see what their social media history is. Go find out what emails are associated with them. Go find out if they have a burner phone. Just something to think about. Find out, maybe if somebody's new into the relationship, are they actually divorced? Are they married? Do they have liens? Do they have judgments? Are they on one of those sex offender registries? And yes, most importantly, do they have a criminal history, right? If you're going to start dating somebody and you find out he's been accused of doing terrible things with children, well, don't you think maybe that some red flags? Yes, it is. Go to crimetalksearch.com. Sign up for that background subscription service today. You can do one search. You can do 1,000 searches. And remember, you can cancel at any time. All right, let's go ahead and open the record for Thursday, August 7th, 2025. And like I said, there's been new security camera footage released from a residence on King Road there in Moscow, Idaho. And it provides some insights into the movements of the vehicle linked to Bryan Kohberger prior to the November 2022 murders of the 4 University of Idaho students. Now, the video was obtained by the Idaho Statesman. Let's give him credit where credit is due. And it documents the repeated passes of a white 2015 Hyundai Elantra identified as Kohberger's near the victim's home of 1122 King Road during the early morning hours. Now, court records and the footage show Kohberger, then the 27-year-old PhD student in criminal justice and criminology at the Washington State University in Pullman, drove the car past the residence 3 times between 3:30 a.m. and 3:58 a.m. Now, the car, registered in Pennsylvania and lacking a front license plates as permitted under state law at the time in Pennsylvania, entered the neighborhood heading south on King Road and turning east on Queen Road at 3:30. It appeared at 3:33 a.m., traveling west on Queen Road before turning north onto King Road and exiting the area. Now, the vehicle returned along the same route at 3:38 a.m., departing again at 3:40 a.m., and during the third pass, it entered at 3:56 a.m. and exited at 3:58 a.m. It re-entered the camera's view at 4:04 a.m., proceeding into the neighborhood. And at 4:07 a.m., the car executed a 3-point turn in the King Road cul-de-sac and headed back towards the victim's home. While prosecutors allege that the murders took place within a 13-minute window following this maneuver. The vehicle was not captured again until 4:20 a.m. when it departed west on Queen Road and turned north onto King Road at a high rate of speed, as detailed in the probable cause affidavit that was support for Kohberger's arrest. Now, the footage also recorded audio elements beginning at 4:17 a.m., including sound resembling voices or a whimper, followed by a loud thug. Concurrently, a dog barked repeatedly for nearly 15 minutes. The camera, positioned fewer than 50 feet from the west wall of the victim's Zana Kernodle's second-floor bedroom, captured these details until the video ends at 4:30 a.m. Now, 5 days after the incident, obviously, Kohberger registered his vehicle in Washington and replaced his license plates, as noted by the lead investigator, Corporal Brett Payne. The victims were University of Idaho undergraduate students, Madison Mogen, Kaylee Gonzalez, Zana Kernodle, and Ethan Chapin, Kernodle's boyfriend, who was staying overnight as well there. Now, all four resided or were present at the home and were fatally stabbed with a large fixed-blade knife, sustaining multiple wounds. That's right, the K-bar. I've got mine after 37 years. Bryan Kohberger lost his within matters of months. Kohberger, now 30, obviously pled guilty in July to the 4 counts of first-degree murder and 1 count of felony burglary to avoid the death penalty. He received 4 consecutive life sentences without the possibility of parole 2 weeks later, and part of his plea deal requires that he waive any right to an appeal or reconsideration or anything post-conviction. So that means it's done, it's final, it's over. So everyone stops saying, oh, I hear he's going to appeal. He's not going to appeal. Otherwise, he starts all over again. And guess what? They'd probably still be able to use his guilty plea against him. That would be quite silly, wouldn't it? Neither the investigators nor the prosecutors have ever been able to establish a motive or a prior connection between Kohberger and any of the victims. And he's currently incarcerated at the Idaho Maximum Security Institution in which is south of Boise, Idaho. It's going to be interesting, ladies and gentlemen, as the information comes out slowly or quickly, depending on the release and how quickly it's been done, as well as the sealed documents, which brings us to our next story as it relates to Bryan Kohberger. Steve Gonzalez, father of slain University of Idaho student Kaylee Gonzalez, has expressed that he and the families of the other victims, Madison Mogen, Ethan Chapin, and Zana Kernodle, opposed the release of the crime scene photographs related to the murders committed by Kohberger. Now, in an interview that he gave to News Nation, Gonzalez indicated that the families have communicated this position to the prosecution, emphasizing their lack of interest in making such images public. Well, the families remain apprehensive about the potential leakage of these photographs, noting that certain details from the case have been disclosed prematurely since the investigation began. And Gonzalez highlighted the risk of awakening to find the images broadcast on television and rejected calls for their release, stating that the victims deserve dignity and such exposure is unacceptable. Judge Stephen Hippler, who was overseeing the case, has announced plans to review the unsealing of evidence, including photographs of the deceased victims, which were part of the prosecution's presentation during Kohberger's sentencing. Now, the judicial order specifies additional sealed documents for consideration, such as the guilty plea advisory form submitted by Kohberger, a list of potential trial witnesses, and the defense materials regarding possible alternative perpetrators. So Judge Hippler has allocated 14 days for the prosecutors and the defense attorneys to file objections to the release of any specific records. Now, parties advocating for continued sealing must provide detailed and a legal basis explaining why redaction would not suffice as an alternative. While the process of unsealing documents involves weighing the public's right to access against the necessity of ongoing confidentiality, particularly in sensitive matters. Now, in the judicial systems, records are presumed public unless compelling reasons justify sealing, with considerations including the impact on public confidence in transparencies. Now, victims' photographs in cases involving serious crimes carry significant privacy implications, differing in sensitivity from items like witness lists. So those seeking to maintain the seal bear the responsibility to substantiate their request. And the judge has indicated that this evaluation will require substantial time extending beyond days or weeks, and has called for patience on everybody. Now, Gonzalez noted that the families intend to safeguard the crime scene photographs and autopsy reports from disclosure. He further mentioned a lack of direct communication from the prosecutor's office following the plea deal, aside from receiving death certificates and autopsy documents, requiring the families to rely on official channels for updates, often learning of developments simultaneously with the public. So this raises very interesting issues. Obviously, public's right to know, presumed to be public, and particularly if it's been filed. If it's in the court records, we should be able to get access to it, except for very limited circumstances. Now, I'm thinking of most autopsies. Most autopsies are really quite boring. Okay, they don't usually include the photographs. That's separate that you get in the file. But in this particular case, and I completely understand with the victims' families that they do not want to see autopsy photos, crime scene photos of their loved ones deceased. It's rather gruesome. I have no doubt. And if you've ever done a stabbing case, usually there's a lot of blood, and it's just it's a mess. It's ugly. Okay. But when I say that people have a right to know, and there's a presumption that these are public records and public information, we should be able to see this. And not because I'm like, oh, great, I want to see autopsy photos. Listen, I've seen more autopsy photos than most people have in their lifetime. And I could eat my lunch looking at autopsy photos. It doesn't bother me, but it could be disturbing to other people. And if they were in fact released, then that would obviously, people shouldn't go look at them. If they don't want to see that, then that's fine. But I think that there's still a way that they can be released with the appropriate redactions, and maybe to even say this isn't the particular person. But the reality of it is people need to see what evil can do and what depravity one human being can have to do horrible things to another person. And like I said, I don't mean this for some spectacle or to want to embarrass the families or anything along those lines. But, for so many people, they want to run around in this little fairy tale world that the world is good and happy and everybody just needs to sing kumbaya and we'll all just get along. And I think maybe the sooner people realize that true evil actually does exist in the world, it'll break people out of this little bubble that somehow they think that everything's lollipops and rainbows and everything's just happy world. It's not. And so that's why I think that there should be public disclosure. Yes, it should probably be limited, but once it gets out there. But hey, listen, you can go see just about anything on the internet. I think we can handle it. And if you don't want to look at it, then you don't have to look at it. I think we should err on the side of disclosure for the public to know what evil looks like and what he did by his own words. And so for all the pro Kohbergers out there, okay, he pled guilty. So for all the people out there who say, oh, I know he's guilty, but the video's kind of fuzzy, he must be innocent. We got this for you. Probably do this on a more regular basis. Is this a pro Kohberger person? Not sure. All right.
That video, you can't even prove it's Bryan's car. The whole thing is a setup. I'm a pro burger.
Next on the docket, let's talk about, yes, Mr. Drummond, the man that went on a rampage. Prosecutors pursue the death penalty in the family massacre. So, how charming. Prosecutors in Tennessee are gearing up to pursue the ultimate punishment against a local entrepreneur. Yes, that's how he described himself for allegedly slaughtering the parents, grandmother, and uncle of a helpless baby who was casually ditched in someone's front lawn like yesterday's trash. Austin Robert Drummond, that 28-year-old picture of innocence, beamed into court via video from his cozy jail cell in Tiptonville just 48 hours after his dramatic capture following a crime spree that had the sleepy backwoods of Western Tennessee clutching their pearls. Now, during this riveting virtual cameo on August 7th, because, hey, why not turn tragedy into some primetime fodder? District Attorney Danny Goodman announced with all the subtlety of a sledgehammer that the state would be aiming for the death penalty. Naturally, Lake County General Sessions Judge Andrew T. Cook decided to keep Drummond locked up tighter than a drum, no bond allowed in such a capital affair. There sat our defendant in his stylish black and white stripes, lounging in a chair as he proudly proclaimed his business-savvy status and demanded a speedy trial, as if there was just another board meeting. Since no lawyer had bothered to show up yet, the judge graciously entered a not guilty plea on his behalf, then deemed him broke enough for a public defender. How generous. Well, of course, he's entitled to it. Anyway, Mr. Drummond faces a delightful assortment of charges: 4 first-degree murders, aggravated kidnapping, and some weapons violations for good measure. His week-long game of hide-and-seek with police wrapped up when he was nabbed in Jackson, a scenic 70 miles southeast from where the July 29th bloodbath took place. The whole nightmare kicked off when a tiny tot in a car seat was discovered plopped in a yard in the Tigret neighborhood, about 40 miles from Tiptonville. Now, according to the Dyer County Sheriff's Office, some thoughtful soul in a minivan decided to play ding-dong ditch with an infant at a stranger's doorstep. Soon after, sleuths linked this to a grisly scene in adjacent Lake County, where 4 gunshot victims turned up. Turns out they were the kids' folks, grandma and uncle, James M. Wilson, Adriana Williams, Courtney Rose, and Braden Williams. Prosecutors state that the 4 hadn't been spotted since the previous evening. A concerned kin dialed emergency services after spotting 2 vehicles in a secluded spot, leading to the discovery of the bodies in nearby underbrush. Well, the Tennessee Bureau of Investigation head guy, David Rausch, assures us this was no random act. Drummond supposedly zeroed in on them like a pro. Meanwhile, the baby is tucked away safely with other family members. And just before his Tuesday takedown, Jackson police released a thrilling 20-second surveillance snippet of someone they claimed to be Drummond, decked in camo and toting a gun, fumbling at a building door like a bumbling burglar in a bad movie. Police Chief Tom Corley credits public tips for nabbing Drummond, who was squatting in an empty structure near the woods. Talk about roughing it. Anyway, Drummond's resume is equally impressive. Stints in the slammer for holding up a convenience store and menacing jurors, plus an attempted murder rap for his time inside the joint. Why stop at just one felony when you can collect them all? Tennessee Bureau of Investigation has rounded up 3 accomplices accused of aiding our anti-hero post-massacre. How touching. These folks really know how to stick together. We'll follow this one, ladies and gentlemen. And, obviously, Mr. Drummond is entitled to the presumption of innocence. But if it turns out that he did, in fact, kill 4 people, certainly seems like the death penalty is ready, willing, and able to be considered for such a heinous crime. Because, if one murder doesn't get you the death penalty, or 2 or 3 or 4, why not stop at 5, 6, 7? Just keep going. If all you're going to do is get the same punishment, life without parole. Anyway, we'll follow that case as it continues. Next on the docket, in a courtroom twist that is equal part dramatic and eyebrow-raising, the young motorist blamed for a high-velocity horror show on Malibu's Pacific Coast Highway showed up with his new legal ace up his sleeve. That's right, the very attorney who turned the tide for Karen Reed in her murder saga. So Frazier Baum, the 23-year-old and facing a storm of charges, made his plea of not guilty in Van Nuys Courthouse on Wednesday, keeping mum with his freshly enlisted counsel. That's right, Allan Jackson. He handled all the formalities in court. Well, Baum stands accused of turning a scenic drive into a deadly debacle back in October of 2023, allegedly barreling along at triple-digit speeds and plowing into parked vehicles, and then tragically struck 4 vibrant Pepperdine seniors: Naim Rolston, Peyton Stewart, Asha Weir, and Deslin Williams. They're all 20 to 21 years of age at the time. And dressed in a somber gray suit, Mr. Baum led Jackson, the Los Angeles legal heavyweight, with a resume boasting defenses for Harvey Weinstein, Kevin Spacey, Phil Spector, and most notably, the recently exonerated Karen Reed, do the talking. Now, Jackson, who jumped aboard this high-stakes case in late June, hinted at brewing challenges for the prosecution during the quick session. Now, the state's got a running start, and we're playing catch-up with a mountain of prep ahead, Jackson quipped post-hearing, suggesting the courtroom showdown won't really ignite until sometime after 2025 wraps up. Police paint a very grim picture. Baum, a local from Malibu, reportedly pushed his BMW to roughly 104 miles per hour on the treacherous 45-mile-an-hour curve on the highway, spiraling out of control and sparking a chain reaction that claimed the lives of the Alpha Phi sorority members instantly at the scene. Miraculously, or ironically, Baum emerged without a scratch, while 2 bystanders nursed injuries from the chaos. Initially arrested on vehicular manslaughter counts, Baum saw his charges escalate to 4 murder raps just days later. His bond started at a hefty $8 million, but got halved following arguments from his prior lawyer about a supposed road rage provocation, a theory the prosecution dismisses as baseless. Now, the victims met their end due to this driver's reckless choices, Deputy District Attorney Nathan Bartos asserted in an earlier hearing. Hitting 104 miles per hour wasn't some fluke, it was a deliberate risk that ended in catastrophe. With a pretrial date set for September 5th, Baum could be staring down life behind bars if the jury doesn't buy his defense. In the meantime, the case serves as a stark reminder that even the fastest rides can lead to the slowest legal grinds. So this is going to be interesting, ladies and gentlemen. Obviously, Alan Jackson, who knows what he's going to come up with, right? I'm sure these girls pushed through themselves into Mr. Baum's car. Ultimately, and you know, they should be apologizing. Their family should be apologizing to Mr. Baum for having to go through this, I'm sure, is the defense that they come up with. Generally, some sort of extreme indifference charge like this, you know, most people kind of get it. And when you got 4 innocent victims, not good, right? What's the general rule? If you got a dead body, usually somebody's got to go to prison. Just a general rule here. Will this one go to trial? Obviously, we will never know until it actually does. But I think it has plea bargain written all over it. And I somehow think Mr. Baum will go do a couple of years in prison. Next is a plea deal brewing in the Donna Adelson case. How utterly shocking, right? Donna Adelson's attorney is flatly denying those pesky reports that she snubbed a plea deal offering her time served in return for ratting out her darling daughter, Wendy Adelson. Now, in the Dan Markle murder saga. Now, because, let's face it, at her advanced age, who'd ever imagined she'd be scrambling for any scrap of a bargain to avoid rotting away in prison? Well, there she was, gracing the courtroom in her final pretrial hearing before the big murder trial showdown. So the question is, if Donna Adelson was handed a golden ticket, time served, if she flipped on her daughter Wendy, well, was she offered a plea deal that was time served and give up Wendy, and she turned it down? I guess we'll just have to wait another day to see if that's really what took place. But wait, when pressed for a comment, Donna's lawyer shot back that no firm offer was conveyed to his client. How convenient. Must be tough negotiating from the golden years. Donna, bless her scheming heart, stands accused of orchestrating the whole murder for hire plot that snuffed out Markle back in 2014. 4 folks have already been nailed for murder, including her son, Charlie Adelson. Wendy, fresh off a nasty divorce from Markle and tangled in a custody war over their kids, hadn't been charged yet, but she did get dragged in to testify against her brother. Family reunions are going to be a blast. They'll probably take place in the Department of Corrections. Anyway, when Jansen was quizzed on whether Donna ditched the deal because she thinks Wendy as pure as the driven snow, or just out of that unbreakable mama bear loyalty, he admitted he hadn't a clue. How mysterious. Anyway, I guess one could completely dismiss the plea deal rumor, completely unfounded perhaps. You know, obviously, attorneys and prosecutors can have conversations in court, but there's nothing formal. And then all of a sudden somebody hears that, hey, they said they may be able to take this or that. And then, you know, a paralegal overhears it or something, or another attorney says to somebody, next thing you know, it's news. Now, I would say the threat of imminent incarceration tends to break the bonds of loyalty, and I have seen it. I have seen it, even with family members. Anyway, the Donna Adelson murder trial, that's right, jury selection kicks off on August 19th. Fingers crossed she finds that elusive deal before then. After all, time waits for no one, especially not the elderly in orange jumpsuits. Next on the docket, a fraudulent nurse. Could you imagine? In a story worthy of a medical thriller. A Florida woman has been apprehended for masquerading as a nurse, administering care for nearly 4,500 unsuspecting patients without so much as a valid license to her name, or rather to be borrowed. Please meet Autumn Marie Bardisa. Now, she's 29 years old, and she now faces 14 felony charges, including practicing medicine without authorization and the fraudulent use of another's identity, as detailed in the arrest affidavit. Adding a dash of entrepreneurial flair to her deception, she is also accused of peddling Ozempic to hospital colleagues and delivering a birth control injection to another. Now, Bardisa, a 7-month stint as an advanced nurse technician at the Advent Palm Coast Parkway in Palm Coast, came to an abrupt end when her superiors, sensing something amiss in her credentials, decided to part ways with her. As the Flagler County Sheriff Rick Staley remarked, "This represents one of the most alarming instances of medical imposter we have encountered, where an individual jeopardizes countless lives by feigning expertise and eroding the foundational trust within the healthcare system." My God, that's right. Can you just imagine the trust in the healthcare system being eroded even further? I guess it's possible. Well, this ruse began back in July of 2023 when Bardisa presented herself as an education-first registered nurse, essentially claiming academic success without the crucial national examination triumph. During the protracted hiring process, she assured the onboarding specialist of her exam passage on October 17th of 2023, and to bolster her facade, she supplied a registered nurse number belonging to another Autumn employed at a sister Advent Health facility, cleverly attributing the surname mismatch to a recent matrimonial name change, though she conveniently neglected to furnish the marriage license as requested. Undeterred by these red flags, Bardisa progressed to complete a nurse residency program on June 20th of 2024, whereupon she commenced patient interactions. Her promotion offer in January of 2025 prompted a routine background scrutiny, revealing an expired certified nursing assistant license. When pressed for the elusive marriage documents, Bardisa offered a series of inventive excuses but ultimately failed to deliver, leading to her termination back in January of this year and the subsequent involvement of law enforcement, spurned by some vigilant co-workers. Investigators later conversed with the genuine Autumn, whose identity has been appropriated. She confirmed attending the same educational institution as Bardisa, but denied any acquaintance. Now, interestingly enough, Autumn had recently altered her surname through marriage, aligning precisely with Bardisa's fabricated tale. Further revelations emerged from an interview with the hospital's chief nursing officer, a woman by the name of Kristen Sutton, who disclosed Bardisa's alleged side venture in dispensing semaglutide, aka Ozempic, and administering contraceptive injections to staff. Now, whether these claims will yield additional charges remains to be seen. But from June of 2024 through January of 2025, Bardisa attended to an estimated 4,486 patients, a staggering figure that underscores the scale of her audacity. On Tuesday, the Flagler County Fugitive Unit executed a seamless arrest at her residence, escorting her to the Sheriff Perry Hall Inmate Detention Facility, where she awaits an arraignment on September 2nd and is currently being held on bond in the amount of $70,000. In this era of credential scrutiny, Bardisa's escapade serves as a reminder why not all who don scrubs wield the scalpel or the syringe with the legitimate authority, at least anyway. Can't make this stuff up, ladies and gentlemen. For those who don't know, I think I've told you, my daughter, nurse practitioner, all kinds of background stuff to go through. Can't believe it took the hospital this long to figure all that stuff out. I know my daughter's stuff took a while. All the licensing boards took a while. So rather interesting that it took so long. I bet you there's going to be some lawsuits for the hospital. Oh, what's that cause of action? That's right. Negligent hiring. Interesting. Next on the docket, this day in legal history. On August 7th, 1786, under the Articles of Confederation, the Continental Congress adopted the Ordinance for the Regulation of Indian Affairs, which established superintendents for the northern and southern districts to oversee trade and treaty relations, representing an initial structured federal framework for interactions with Native American tribes. On August 7th, 1789, the United States Congress enacted legislation titled An Act to Establish an Executive Department to be denominated by the Department of War, thereby formally instituting the War Department as one of the initial cabinet-level executive agencies responsible for military administration. On August 7th, 1794, prominent Republican congressional leaders convened with President Richard Nixon to convey the inevitability of his impeachment and removal from office amid the Watergate scandal investigation, obviously precipitating his resignation the following day and underscoring a critical juncture in executive accountability under federal law. On August 7th, 2010, Elena Kagan was sworn in as the 112th Associate Justice to the United States Supreme Court, marking a significant judicial appointment and enhancing the court's diversity. And our legal quote of the day has to do with right of counsel. Kind of going back to our Mr. Baum story and hiring Alan Jackson. The right to choice of counsel in criminal proceedings is a fundamental aspect of the Sixth Amendment to the United States Constitution. A key judicial interpretation of this right appears in the United States Supreme Court decision of United States versus Gonzalez-Lopez, a 2006 opinion, where Justice Scalia, writing for the majority, stated, quote, "The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. We have previously held that an element of this right is the right of a defendant who does not require appointed counsel to choose who will represent him," end quote. So this holding of that case underscores that the deprivation of defendant's preferred counsel, absent valid justification, constitutes a structural error under the Sixth Amendment, requiring no further demonstration of prejudice to the trial's outcome. Basically means is if you have private counsel in a criminal case and you show up the day before trial and say, I don't like that counsel, I want this new guy, the court's probably going to have to give it to you unless you can show that there's been a pattern of delay. And this is a pattern in which people engage in. Saw this once. Guy would hire attorney before trial. He would fire his attorney, get a new one on. And ultimately, the court told this client that you can come on the case to the new attorney, but we're still going to trial on Monday. So you do what you have to do. The courts have seen all the games. Everybody thinks that they're going to play the game better than the last guy. The court knows the games. They all do. And anyone who's been around the system for a while knows when they're playing games. Next, he McFlipped his lid and landed in McLockup. That's the Florida sheriff who delivers a pun-filled roast of an 18-year-old who menaced a McDonald's over botched McNuggets. In Polk County, Florida, and I love this guy, Sheriff Grady Judge has cultivated a considerable following on TikTok through his daily dispatches on apprehended criminals of questionable intellect. It's kind of like his own dumb criminal of the day, but we started it first. Well, this week, Judge achieved viral acclaim anew by skewing an imprudent 18-year-old offender who escalated a fast food faux pas into a felonious fiasco. Meet Dayton Schaefer, yes, 18 years old, who ventured to McDonald's only to find his order awry, apparently missing a coveted McNugget. As events unfolded, it became evident this individual behaved as a verifiable McNut. Sheriff Judd proceeded to lambaste Schaefer with a cascade of McDonald's-inspired witticisms through the presentation. This McNut, derived of his McNuggets, directed from McDonald's, resorted to his McPhone for a McThreat against the establishment, employing his genuine contact details, rendering it a leisurely McPitch for our deputies to execute McArrest. In any event, he is now in the McJail. Dane Schaefer of Lakeland was upset about his fast food order not being correct, and he overreacted. Way overreacted. So we made sure he got his criminal charges correct, according to the sheriff judge. Anyway, prospective perpetrators in Polk County, Florida would be wise to reconsider their illicit inclinations, lest they become the unwitting stars of Sheriff Judge's satirical social media spotlight. I like Sheriff Judge. I do. He's good, but we started the dumb criminal first. I swear we did. All right, that's all we have for today. Hope you enjoyed the show. We'll see you next time. And remember, the Constitution matters.